All right, good morning, everyone. Let's get started. We're now live on YouTube. So get started with today's civil docket for March the 21st, 2022. As always, I'm going to ask everybody to please remain on mute until such time as your case is called. Please remain on mute so that we don't have any interference with our audio. Once your case is called, you can go ahead and unmute yourself. I will take quick announcements first. Any attorney with a quick announcement with all parties present, I will take those announcements first. If you could just give me a reaction button, raise your hand, let me know that you're ready to have your case called. If not, I will kind of move through the docket. Mr. Guajardo, I see you with a reaction button. You're on mute, sir.
Good morning, Judge. How you doing?
Good morning.
I'm glad I did the buzz quicker than anybody else and got first. Your Honor, we're here on cause number CL 203593H. I think Mr. Hodges is online as well.
That's number 17 on the docket.
I believe so, yes, Judge.
Raquel Canales versus Damaris Favela and Javier Favela.
That's correct. Your Honor, we're set for a motion for summary judgment. A defense counsel filed, and we filed a motion for continuance on this matter. So I figured we can have a motion for continuance heard first. And I know Mr. Hudgens is opposed to it at this point.
All right, I'll go ahead and hear that. Mr. Hudgens, I see you present. Can you hear me?
Yes, I can hear you, Judge.
Okay, great, perfect. All right, so then, Mr. Guajardo, you were urging a continuance.
That's correct, Your Honor. This I filed a motion for continuance timely on Thursday. This case was set back on, I think, February 29th for this motion for summary judgment. But on February 3rd, I had a federal case with Judge Micaela that was set for the same day for today. And as the court would know, we don't have Zoom hearings in federal court. They're live hearings. So I would have had to been present there. And it would have been of utmost importance that I be there because we had a motion to remand. And Judge Micaela, I filed my motion on Thursday at about 1:15, and Judge Micaela Alvarez did something that surprised me, and I've never had that done before. She granted my motion to remand, and secondly, she granted it before a hearing. So I've had motions that are agreed to be remanded that I've gotten denied nonetheless. So I didn't expect that at all. So about an hour and a half later, after I filed my motion for continuance, she granted the motion. So we don't have to appear in federal court, and hence I'm here. But I had all intents and purposes of filing a motion for continuance because I can't be in two places at once. I just inadvertently waited until Thursday to get this done. I should have done it a lot earlier, but nonetheless, I filed it timely. So needless to say, Judge, I'm not ready for the motion for summary judgment. We need more time. I know counsel is opposed to that. I'm sure defense counsel practices in federal court as well, and he must know we need to be there or have consequences. So at all point in time, Judge, I always expected to be in federal court and not here. So I should have filed my motion a while back, even though I filed it timely. That motion or that hearing, that initial pretrial conference was set earlier than this motion. So that was set on February 3rd.
All right.
I'm asking for the court. I'm sorry, Judge. I'm asking for Your Honor to grant me a continuance at least 30 days so we can file an answer and get ready for a motion for summary judgment.
Okay, so I guess there has been no answer on file. There's no response to the summary judgment.
That's correct, Your Honor. I always had the intention to file a continuance because, like I mentioned, I needed to be there. But then again, like I said, Judge Alvarez surprised me on those two accounts. First of all, granting it, and secondly, without a hearing. I've never had that happen. So it's a first for me. And I would expect counsel to be more understanding about that, but apparently he's not. He's opposed and wants to go forward on his motion. At least that's the last I heard.
Let me ask you, Mr. Guajardo, was it just an oversight that you didn't file a response? Because, I mean,
well, Your Honor, I did not file a response because I did expect to file a motion for continuance nonetheless, and I expected to have that heard earlier. So my mistake was not filing my motion for continuance a lot sooner. And I didn't expect to be ready for this hearing. And I quite frankly expected the court as well to give me a continuance because as you know, I had to be there in federal court.
All right, Mr. Hudgens?
Judge, I think you kind of brought up the issue. If, from my perspective, for my clients, which we don't think we should be in this lawsuit, Mr. Guajardo reached out to me, I believe, on Wednesday or Thursday, I can't remember, of last week, regarding the continuance. And I saw that he hadn't filed a response. If he had filed a response, I wouldn't have had a problem with continuing today's hearing. But because he hadn't timely filed a response, I've got to zealously advocate for my clients. I couldn't agree to the continuance.
Right.
And then when I saw what with his basis, I've been in judge. I've got several cases in Judge Alvarez's court. I know exactly what he's talking about, and I agree with everything he's saying. I probably was a little bit of a surprise, but I didn't know the timing when last week was my kid's spring break, so I wasn't working. I wasn't sitting in front of the desk. But when I got his email, I did timely respond that I was opposed. And then when he filed the motion, I had my associate. I said, "Can you just go ahead and respond to this?" And that's when he found that the remand had been granted. And so I'm not accusing. I don't think Mr. Guajardo was trying to mislead the court with his motion for continuance. It's really more an issue of timing. If he had come to the court, or if he even asked me a week and a half ago before his response was due saying, "Hey, I got to continue this," I likely wouldn't have had a problem. I wouldn't have to go to my clients and ask them. It's because he didn't file this till after his response was due, and he didn't file a response. So that was the reason I was opposed to the continuance. And I understand his dilemma. I'm not disputing that, but that's the reason I was opposed to continuance, because he had not filed a timely response.
Right.
If I may respond, I guess Mr. Hudgens is alluding that he wants to take advantage of a situation where I didn't file a response, because that's what it sounds like.
Look, Mr. Guajardo, and let me just kind of let's stop sometimes you can escalate problems. I think from what I'm gathering from Mr. Hudgens is he's zealously representing and advocating for his client, and he couldn't, in good conscience, agree to a continuance, because that would fly in the face of representing his clients, which we all have to do that, right? We all have to zealously advocate for our clients. But what I can do is I can grant your continuance, and then go back to his clients and blame the court, which we're used to that.
I will not blame the court, Judge. I will say the judge, using his discretion, decided to grant the continuance. It's perfectly fine it's within his discretion.
It's within.
I won't blame you.
Right. Well, I'm not saying that.
I know.
We all have to. You all have jobs to do, and I totally understand it and respect it. And my job is to try to keep the docket moving, right? To try to keep it flowing. And I don't feel that at this time granting Mr. Guajardo a 30-day continuance, kind of stalls the process all that much. And so for that reason, the court will go ahead, Mr. Guajardo, based on your representations you've made this morning. I'll grant you that continuance, allow you to file your untimely, but I'll grant you the leeway for the court to file your response. And then I'll give Mr. Hudgens an opportunity to respond. If you don't mind, I will give you a deadline to do that, to file your response 2 weeks down the road. So I'm going to reset this for 30 days. I'll give you two weeks to file your response. That way, if he has any responses or a response to your answer, he can go ahead and do that. The reset date will be the 18th of April. April 18th.
Your Honor, I also want to bring something else up, though. I think even the motion at this point is premature. We still need discovery. I've been asking Mr. Hutchison to give me some depot dates for one of the defendants. I have not gotten a response to that. So I'm not sure. I mean, we can go ahead and do that, and that can be one of my arguments, but I would have really appreciated to do I'll defer to Mr. Hutchins. If he wants to present his client, maybe we could get more time to file a response. But if he can't do that at this point, then I'll go ahead and just abide by this timing and this deadlines, and we'll go from there. But I really would have wanted to have another depot done.
Yeah, Judge, this is a dog bite case. He sued the husband and wife that owned the dog, my clients, and in full disclosure, I've been trying to get with my clients to get a depot date. One of my clients, I think the court may recall, is a Border Patrol agent. He's very difficult to get in touch with just because of his job. And I fully agree with Mr. Guajardo that he should have a right to depose my client, the wife. He's already deposed the husband. And if I could present her this week, I would try to. I'm having some trouble getting in touch with my client, quite honestly, on that.
Let's do this. I'm going to leave the date of April 18th at 9:30. I will be expecting maybe argument on the summary judgment. If we need to pass it at that point, let's all get together, reconvene. Let's see where we are with the depots, and we'll reconvene on the 18th. I think that satisfies everybody. Is there our immediate need of more time? It's satisfied by granting this small pause so that we can go ahead and take care of that.
It's fair enough, Your Honor.
Thank you, Judge. Appreciate it.
We'll see you on the 18th at 9:30. Thank you, gentlemen.
Thank you, Your Honor. May I be excused, Your Honor?
Yes, both of y'all are excused.
Thank you, Your Honor. Have a good week.
You too. Mr. Barbosa, what do you have?
Good morning, Judge. I'm here in CL 210528H. I apologize, Judge. I don't have a docket for this morning.
All right. Number 14, Sixto Castillo Salas, Esther Herrera, Angela Martir, Cantalina Morales versus Alejandra Morales.
That's correct, Your Honor. On the other side is Karina de la Garza, Judge. I just spoke to her a little while ago. She couldn't make the hearing, Judge, but she's unopposed to our announcement. We're just asking for a little bit more time on this case, Judge. We're waiting on the mediator's proposal from Gil Peralez's office. We're hoping once we get that, we should be able to hopefully wrap up this case.
All right, this one is sitting at number 6 of 6 for the week, Mr. Barbosa. So I guess what I'll do is I will just make the note that y'all are waiting on a mediator's proposal. We'll enter that into our system and we'll see each other on April the 7th, okay?
Okay, no problem, Judge.
See you there April 7th.
Thank you, Judge. That's all I have. May I be excused?
You're excused. Mr. Ramirez, what do you have?
Good morning, Your Honor. I have two cases here. The first one is Francine Falcon versus Ofelia Luna.
All right, that's CL 19-1386H, Francine Falcon versus Ofelia Delgadillo Luna, sitting at mandatory trial status, sitting at number 2 for the week.
Mike Tuttle on behalf of plaintiff, Your Honor.
And Ruben Ramirez on behalf of the defendant, Your Honor.
All right, good morning to both of you. Mandatory trial status, where are we, gentlemen?
Your Honor, we've conducted the depositions of the parties. We've mediated the case unsuccessfully. It looks like the case will go to trial, Your Honor, but there's things that we're going to need to do to get ready for that. And so I think we're asking if we can either set it up for new DCC or set it up for, pushing it down into, late summer, early fall, Your Honor, for a trial date.
That is correct, Your Honor.
Okay, so Mr. Tuttle, as long as we're aware, this is sitting at number 2 for the week. I cannot, without you all announcing ready for trial, I can't promise you any future dates. What I can tell you without a shadow of a doubt, that our dockets are full because we're 2 years backed up, and I can't, sometimes as plaintiff's counsel, you guys want, quick trial dates. If I give you this continuance, you're sitting at number 2. If I grant you this continuance, then there's no guarantee that it'll even be this year. It'll probably be into next year because of how loaded our dockets are. And you're not announcing ready for trial today. If you were announcing ready for trial and I didn't get to you, then you leapfrog other courts and other cases. And that's just kind of the way our system is set up. If you're okay with that, Mr. Tuttle, I have zero problems granting you a continuance and granting both of y'all some additional time.
That's understood, Your Honor.
Okay, let me give you a new DCC. All right, let's do March the 29th, 2022 at 2:30.
Thank you, Your Honor.
No problem. So we're going to remove you from the trial board for the week of April the 11th. And we will give you that DCC and you guys can reconvene telephonically on that DCC on the 29th of March, 2:30.
Thank you, Your Honor.
Perfect. Thank you, Your Honor. I have one more case before this honorable court.
Yes, you have the number CL 186546H, Reynaldo Martinez versus Noemi McCullough. We have Rogelio Garza, who's, this case is sitting at number 1 for the week.
Rogelio Garza on behalf of the plaintiff, Your Honor.
And Ruben R. Ramirez on behalf of the defendant, Your Honor.
We both spoke this morning, Your Honor. We feel it's to our advantage to ask for a motion for continuance at this time because we have more depositions to be done, especially of the defendant and the defendant experts.
Okay,
That's correct, Your Honor.
all right. Now, Mr. Garza, you've heard what I've just mentioned. You're okay with the fact that this might take you into next year?
That is, I'm okay with that. Thank you,
Okay.
Your Honor, for
No
asking.
problem. DCC 329 at 3 o'clock.
Thank you very much, Your Honor.
All right,
Thank you,
that
Your
will
Honor.
be from the docket board for the trial on April the 11th.
Thank you, Your Honor. That concludes my business with this honorable court. May I be excused?
Both of y'all are excused. Thank you so much.
Thank you. God bless everybody. Have a great one.
Likewise. Mr. Moore, what do you have?
Yes, sir, Your Honor. Myself is Oscar Gomez is on the Zoom also. It's on CL 203760H.
Rene Ortega, Elizabeth Ortega versus Emilia Mendiola, the estate of Guadalupe Mendiola, a deceased.
Yes, Your Honor. Visiting with opposing counsel, we've agreed to go to mediation on this case. There's been no discovery done because there's a pending motion to dismiss certain causes of action. So there's been a hold on the case, but we've agreed to go to mediation if we can get a reset, Your Honor.
Give me 1 second. Okay, so you are asking for some additional time to go to mediation, parties to attend. Mediation. Attend mediation and a new DCC. Let me give you the same date for the DCC. That'll be on 3/29/22 at 3:30.
Great, Judge. Thank you so much.
You're very welcome. Thank you, guys.
Thank you, Your Honor.
Y'all have anything else?
That's
That's it,
all we
Your Honor.
have. May I be excused?
You're excused. Thank you.
Thank you, Judge. Have a nice day.
You too. Mr. Kennedy, what do you have?
Morning, Judge. I'm afraid I don't have the docket number, but I have F 4349-21-8.
That is number 8. It is in the matter of the marriage of Jose Martin Contreras versus Estela Ivana Escobar.
Yes, Your Honor. Judge, I represent Mr. Contreras, and we're asking for a default hearing in 45 days.
All right, how about April 27th? Does that day work? Or do you need a little bit more time than that? We can do May 4th as well.
That'd be fine. May 4th is fine, just to make sure that the respondent gets adequate notice.
All right, May 4th at 9:30. May 4th, 9:30.
Thank you, Judge.
Now,
That's all I have today. May we please?
do I have Estela?
Yes, I'm here.
All right, Mr. Kennedy, were you aware that she's present?
No, I was not aware.
Okay, Estela Escobar, are you the respondent in this case?
Yes,
All right. Ms. Escobar, are you represented by an attorney?
no, I am not.
All right. And has she been served, Mr. Kennedy?
I believe so,
assume
Judge.
I assume
Yes.
you were trying to take a default? All right. And
I wasn't served. No one had notified me till Mr. Contreras called me and told me about this court we had today. So I had to get a hold of the Mr. Contreras attorney for they could send me the Zoom meeting.
did you happen to sign a waiver of service, ma'am?
I signed something and I took it to Rubio, but I don't even recall what I signed.
All right, I'm gonna
I
share,
did send them my address and everything so they could send me the letter for the court and everything, but I never received anything.
I'm gonna show you a screen on the, look, can you see the screen? I'm gonna show you
A ver,
the waiver of service, just to make sure that this is your signature. Give me 1 second, it's not up yet. Here it is. Is that your signature down at the bottom? Give me 1 second. Is that your signature there? Can you see that? You're on mute, ma'am.
I'm so sorry. Yes, that was me.
That's your signature?
Yes.
Okay. All right. Patrick, if you can stay in contact with her, do you happen to have her information so that y'all can see if something can get resolved and worked out?
I think our client has her contact information, but we can kind of work it out.
All right, the court's gonna go ahead and take your appearance here today as a general appearance, Ms. Escobar. I am gonna ask for some information so that my office can have it, and that is your email address, Ms. Escobar. Can we please have your email address?
Yes. It's Estrella 41911 at gmail.com.
All right, and a phone number, please.
956-274-6270.
Okay, then what we're gonna do is I'm just gonna continue this to May the 4th, unless you think we don't need as far a date, Mr. Kennedy.
I don't think we do.
Okay, Judge, if you want to make it sooner, we may be able to work it out sooner than that.
All right, let me go ahead and I'm gonna give you April the 11th, Ms. Escobar. April the 11th, I am gonna ask that you stay in contact with Mr. Salinas's office, Rubio, or Mr. Kennedy's office, and see if something can get worked out on this case, okay? If not, we can log back on April the 11th, and we'll take an announcement at that time.
Okay, because we're both and then agree for the divorce.
Okay, well, maybe at that point, you can speak with Mr. Kennedy, and if both of y'all are in agreement, y'all can reach and enter into an agreed order. But that way they can work on the order, they can give you a copy of it, you can review it, you can discuss it, and if you're in agreement with it, you can sign off on it.
Okay.
All right, we'll see you on the 11th at 9:30.
Thank you.
Judge. Have a good day.
You too. All right, let me go back to, anyone else have an announcement to make and ready to make an announcement? Mr. Sabo, you have, you're on my mandatory trial status, CL 192484H, Mark Duarte versus Paula Rangel.
Yes, Judge.
All right, who's on the other side? Juan Gonzalez?
Yes.
Mr. Gonzalez, good morning. Can you hear me, Mr. Gonzalez?
Yes, Judge, can you hear me?
Yes, I can.
Good
Thank you.
morning. Here
Good
for
morning.
plaintiffs.
All right, your announcement, either Mr. Gonzalez or Mr. Stable, on the trial status.
The hearings we have also set today may actually impact that for both of us, Judge.
Oh, that's right. You have a motion to exclude designated expert and motion to compel, correct?
Yep.
All right. Let me get an announcement real quick from Ms. Vasquez. Ms. Vasquez, I know we're waiting on Mr. Jackson. I don't see him logged on, but you're one up at this point, given the fact that number 1 and 2 have asked for additional time. On CL 19-2024H, Maricruz Cavazos versus Melissa Lopez. To your knowledge, do you have an announcement on that case? Are you all ready?
Yes, Your Honor. Good morning. Lisa Vasquez Garza on behalf of the defendant. Judge, it's been slow moving, this case. So I guess the short answer is no, it's not ready to proceed to trial. Just as a brief history, this is a case that's involving a minor, and the policy limits have been extended. Mr. Jackson takes issue with the timing of it based on whatever he did pre-suit. There hasn't really been any movement on this case. I have followed up with him several times to see if he's ready to finalize it, and have gotten no response. So last week I did send him another message that if we were not going to be able to get the matter resolved, then I'd like to depose his client and move things along, as it was always my impression that the case would be resolved. And unfortunately, I have been unable to speak to Mr. Jackson. So the short answer is it's not ready, Judge. Trying to see what I can do to get Mr. Jackson to take a look at this.
Okay. Well, then let me do this. Clearly, there's still some work to be done. I will
Yes,
give
sir.
you an ECC date. If Mr. Jackson is not here to voice an objection to that, I'll give you March the 28th at 2:30. March 28th at 2:30.
Thank you, Your Honor. May I be excused?
You're excused.
Have a good day.
Likewise. Okay, so Mr. Sabo and Mr. Gonzalez, just FYI, this puts you now at number 1 for the week. So just FYI, for what it's worth, I know I'll need to come back and take care of a couple of matters, but you are number 1 now that we have all the information. Let me take a few more announcements before we take up your motions in case we have some maybe quicker matters. Mr. Orlando Jimenez, is yours somewhat quick?
Yes, Your Honor. Good morning, Your Honor. Good to see you again, Judge.
Likewise.
I have a Miss Pettit with Mr. Jonathan Ball on the other side.
Good morning, Your Honor.
Good morning. Let me look for that case. It's F 4977-18-8 in the matter of the marriage of Kyle Pettit and Victoria Pettit.
Your Honor, good morning. Orlando Jimenez on behalf of Miss Pettit.
Jonathan Ball for Mr. Pettit, Judge.
Your Honor, we recently received the social study report and investigation findings, Your Honor. As a result of that, Your Honor, I'm humbly and respectfully requesting a little bit of time because there is some information that came out of that social study that I think is very helpful and will be very fruitful in trying to resolve this matter. And so we did mediate this case, but that was pre-social study. And now that we have it, I am talking to my client, and I think we are hopefully going to be a lot closer in trying to settle this matter. So with that said, Your Honor, I am respectfully requesting maybe a 30-day reset so we can try one more time at mediation. And I am optimistic and hopeful that we can settle.
Mr. Ball?
We had quick back history. My client works in the oil fields in New Mexico, and we had previously mediated, and what we had requested was that mom work with him on his schedule. He's asking for his 10 nights a month, which is basically what he'd get on a standard possession order. We were told there wouldn't be any negotiating in that respect, and that he either took a standard possession order and missed his days when he wasn't here, or there was no movement. The social study was done better than a month ago, I think probably a couple of months ago, and it recommended that he basically have a floating schedule, that he get his 10 days each month, pay child support, all that kind of stuff. We were previously here at a hearing. Same announcement was made. We said we're ready to go, and all we're asking is that the court enter the social study as done by Mr. Acosta. So we're back. This is probably our third, maybe our fourth final hearing that we're at. My client is still having issues getting regular visitation and access to the child. I understand Mr. Jimenez's position. I'll leave it to the court to decide what to do, but frankly, we would rather, and I do have Mr. Acosta on standby. I've contacted him. My portion of what this hearing would take would be, I would put him on, have him prove up the social study, admit it into evidence, and ask my client to testify what he's asking for. And that would be the extent of it. We're asking for JMCs when he's in town, that he gets his days with his child, and that's it. He's going to pay child support by the guidelines. I don't know what else there is to negotiate.
Mr. Jimenez, is this something that you feel that because of in light of the social study and what the recommendation of Mr. Acosta is, that your client might have a difference of opinion and a mediation would be fruitful? Is that kind of where you're kind of coming from, or?
Exactly, Your Honor. That's exactly where I'm coming from.
When was the last time that Mr. Pettit had any visitation, Mr. Ball?
Mr. Pettit, are you on?
Yes, sir.
Mr. Pettit, sorry, Judge.
Sorry, go ahead, Mr. Ball.
When was the last time that you had visitation with your son?
Give me 1 second. I apologize. I can't give you the exact dates. I apologize. It was this last.
Best guess is fine.
Yeah, I mean, I did have him last month. I guess I did have him last month for my one weekend that I was able to actually pick him up. The exact dates are, I believe it was the first weekend of the month.
So since last month on that one weekend, you've not had access to him. Is that correct?
No, sir. It was March 4th through the 6th, I believe. Yes.
And despite that, Have you been in town since that date?
Yes, I still had about, I want to say 12 days at home before I came back to work. I'm currently, as of right now, I'm in New Mexico at working.
And
When is the next time you would have availability? What I don't want to do is I want to grant Mr. Jimenez, I'm just going to tell you what I'm thinking, right? I want to grant Mr. Jimenez the time that he feels would be fruitful, because obviously I would much rather you all make a decision about what's in the best interest of your child, as well as yourselves, both of you. And I'd much rather that you all go to mediation and sort those issues out before you force the court to make the decisions that may not be in the child's best interest or your best interest. I'll always do what the court feels is in the child's best interest, but sometimes that's not always, I don't always have all the information, let's put it that way, right? Even though we try our very best. So I want to have Mr. Jimenez, I want to give him that opportunity, but I also don't want to, I don't want to stand in the way of Mr. Pettit having visitations if that's been an issue. And so if he's going to be gone for the next couple of weeks and that's not going to be an issue, maybe I can schedule mediation in the next couple of weeks, and then we can then come back in about 2 weeks and see where we're at. I just kind of wanted to get that information.
I would not object, Your Honor, if the court could put a time restraint on it to about 15 days to mediate, and then maybe give us a setting a week after that, somewhere in that neighborhood, just so that we keep those time constraints short. We get everybody to the table real quick, and it's either yes or no at the mediation.
Yeah,
Like
I would agree with that, and I know Mr. Jimenez does too. Now the question is going to be, now one of the things that's out of our control is getting a mediator that can maybe handle this in the next 2 to 3 weeks. If you all have any suggestions, or if anybody has any recommendations.
I'm confident that Edna Cedillo or Lucy Thompson, Roby Flores, there'll be folks that I think Mr. Jimenez and myself can agree on that do a lot of family law. Somebody will be available.
Mr. Jimenez?
Absolutely, Your Honor.
Okay, let me then go ahead and reset this case for 3 weeks down the road, and that'll give you hopefully the next 2 to up to 3 weeks to give us an answer to the 13th of April. April 13th, 9:30.
Thank you, Your Honor.
We'll be here, Judge. Thank you so much, Your Honor.
Thank you, guys.
We'll see you soon.
Bye-bye. Thank you.
All right, Ms. Barreto, what do you have?
Good morning, Judge. I have F3794218. Here on behalf of petitioner Sergio Garcia. He's in my office, Judge.
All right, in the matter of the marriage of Sergio Garcia Jr. and Alexandra Ramirez.
Yes, Judge. She is on the Zoom as well. The last time we were here, she had asked for more time to hire an attorney, which she did, Judge. It's Juan Ramos. I believe he's in the 370th right now, but him and I talked this morning and we're in agreement to pass this case so we can come up with an agreement, Judge.
Ms. Ramirez, can you hear me?
Yes, sir.
All right, perfect. Ms. Ramirez, your attorney and Ms. Barreto have agreed to pass this case. So unless I hear an objection from you, I'm going to go ahead and grant that request, allowing the parties the opportunity to try to confer and maybe reach an agreement. Do you have any objection to that?
No, none.
Okay. Pass by agreement. If you can just submit a Rule 11, Ms. Barreto, just so that we can have it on our file. And then what do you think, 30 days? Would that be enough time?
Yes, Judge. That's fine. And if we get an agreement before, we'll move it up. We'll call the court.
Sure, no problem. Let me go ahead and give you April the 18th, 2022 at 9:30. April 18th, 9:30.
Thank you, Judge. That's all I have. May I be excused?
You and Ms. Ramirez are excused. Thank you.
Thank you.
Thank you.
Ms. Niedowitz, what case do you have?
Hi, good morning, Judge. I am appearing on behalf of Amy Cogan. This is U.S. Bank versus Mr. Tesoro.
All right, this is CL 212510H. U.S. National Association versus Tereso
Oh,
Morano.
I'm sorry. Yes, Teresa Morano. I apologize.
Yeah, no problem. Tereso Morano. Is Tereso Morano present? Tereso Morano? If you're on mute, please unmute yourself. Tereso Morano. This case is set for default judgment hearing. Court's going to take judicial notice of all documents in the court's file, including the filing of this action. On July 14, 2021, citation was issued on July 14, 2021. Defendant Tereso Morano was served on October the 25th, 2021. It was returned to the clerk on October the 27th, 2021. To date, there's been no answer on file. Name of Tereso Morano has been called out 3 times. There being no response, you may proceed with your default.
Yes, Judge. On this, Your Honor, as the court stated, the defendant was served on, the suit was filed against the defendant on July 14th, 2021. The last known address that we have is 28809 Jessica, Edinburgh, Texas, 78541. Defendant is not in the military. A citation was issued and executed. The deadline has passed for his response and none has been provided to the court. And so we are asking the court for a default judgment in the amount of $42,724.35, Your Honor.
All right. Any costs of court or attorney's fees or?
Give me 1 second.
It does? I'm sorry. It looks like there in the default judgment, there is cost of court in the amount of $294.27 and service costs of $85.
$85, yes, Your Honor.
But no attorney's fees from what I'm seeing.
The attorney's fees, I don't see them on there, Your Honor.
Okay. The court will go ahead and grant default judgment in the principal amount of $42,724.35 plus court costs in the amount of $294.27 plus service costs of $85. That relief is granted.
Thank you, Your Honor. That's all I have.
We do have an order, Ms. Dietowitz. The court will sign off on it and you can grab a copy of it hopefully this afternoon.
Thank you, Your Honor.
You're welcome.
Appreciate it. Have a great day.
You too. Mr. Gomez, what case are you here on? Mr. Gomez, can you hear me or are you on another Zoom call?
I'm sorry, Your Honor. F1607-F.
All right, that is F0720-8 in the matter of the marriage of Lorena Gonzalez and Macario Ibanez.
Yes, Your Honor.
I do have Mr. Macario Ibanez on. Do you represent Lorena Gonzalez or Macario?
No, Your Honor, I represent Mr. Ibanez. That's what we're here for. I filed a motion to withdraw. Ms. Gonzalez filed by David Guerrero. I saw him on earlier. I don't know where he went. Oh, never mind. Sorry.
I'm here on the same matter, Judge, but there is a motion to withdraw on file.
Okay. Now, Mr. Ibanez, the reason why I muted you is there's some interference. I'm not sure if you have multiple devices on, but since you are currently represented by Mr. Gomez, I'll allow him to speak on your behalf. Maybe we can try to fix that slight issue that we have. Okay, so Mr. Gomez, you're asking to withdraw from representing Mr. Ibanez. Is that correct?
Yes, Your Honor.
And Mr. Ibanez, now you can go ahead and unmute yourself. Maybe hopefully muting and unmuting yourself will fix that problem. All right, I think we may still have that issue. It may be a connection issue. Mr. Gomez, Mr. Ibanez, are you aware of the request from Mr. Gomez? Mr. Ibanez, can you hear me? All right, do you have any objection to Mr. Gomez withdrawing? Mr. Ibanez, I'm going to give you a phone number. I'm going to ask that you call our office and I'm going to try to log you in through our audio here at our office. Okay? Okay, Mr. Ibanez, the number is 292-694-5800. 7740. Go ahead and please place yourself on mute, and if it's possible, I don't know if you're using your phone, but call our office and we'll patch you in through one of our staff members' audio.
He's on the line, Judge.
Okay, perfect. Mr. Ibanez, can you hear me now?
Yes, sir. I can hear you now, sir.
Perfect, thank you. Mr. Ibanez, Mr. Gomez is seeking to withdraw from your case. Were you aware of that?
Yes, sir.
Right, and do you have any objection to him withdrawing?
Oh, no, Your Honor.
Are you going to be seeking to hire a new attorney, or are you going to be going pro se on your own?
I was going to seek for another attorney, sir.
All right, Mr. Guerrero, Mr. Ibanez is asking for some additional time to hire a new attorney. Do you have any objections or any information to share with the court with respect to any issues that may have come up that we need to address, or can I go ahead and grant that request at this time?
We have no opposition to him having a counsel represent him. Obviously, he can hire someone, but we just want to make sure that when he does substitute out, that we can get our matter set, Judge. We had some temporary orders, modification hearing, and some time back, we submitted an order pursuant to what was adduced at that hearing. And then Mr. Ibanez, of course, did not like the result. So if he's going to have a new lawyer show up, can it be when we have the hearing also, so we can kind of take care of both things? My client's been waiting for this modification. To his credit, he has followed some of the modification, but not the child support portion of it.
Okay. Mr. Ibanez, how long will it take for you, or how much time are you requesting in an effort to try to hire new counsel? How much time are you requesting?
Your Honor, I'll be hopefully about a month or a month and a half. I gotta get the money. I have to raise the money for it.
All right. Let me do this, Mr. Gomez. Let me first take care of your request, and the court will go ahead and grant your request at this time. So I will relieve you of your responsibilities and your duties, and thank you for logging on and making that announcement.
Thank you, Your Honor.
You're welcome. Mr. Ibanez, I have no problem in granting you 30 days to seek new counsel. Okay. So I'm going to go ahead and reset this case for 30 days, but I am going to consider anything and everything that Mr. Guerrero is bringing to the court's attention in 30 days. So that gives you 30 days in which to be able to get prepared, but in 30 days, the court will listen to Mr. Guerrero and any requests from his client, okay?
Yeah, thank you for that. Thank you for that, Judge.
All right. Mr. Ibanez, do you have any questions?
Your Honor, I had a question about the last time we came into meeting on the motion on the modification, Your Honor, about the child support. The thing about it, sir, I'm feeling that my rights are been violating. Because last time we went to court, Your Honor, sir, that the other party, sir, gave me a sum that I had made on 2018, a total of $30,518. Supposedly that was only my only income, but in that year on 2018, also Ms. Lorena also worked that year. She had made 23,000, and I only made 6,000, Your Honor. So in other words, this is violating my rights, Your Honor.
Okay. Are you claiming that you didn't make the amount of money that Mr. Guerrero alleged that you made because that money was made by Miss Gonzalez?
I can hear you, Your Honor. Sorry about that.
No. So is your argument that that the information was incorrect, that was shared with the court?
Yes, Your Honor.
Okay. And do you have any proof of your income for 2018?
Yes, Your Honor.
And have you shared that with Mr. Guerrero?
Well, by the time I had sent it to Mr. Gomez that time, And I don't know, he sent her, Ms. Lorena's W-2 form to, I don't know if he sent her or not. That's the thing about one of the arguments we had gotten to, it's not, there's something we got into. But one thing is that year, I have her W-2 form, I got from the taxes. Hers was 23,000 and mine was 6,500. And I have the W-2 forms, I can show it to you on.
All right. Why don't you forward those to Mr. Guerrero? And then we'll come back in 30 days. In the meanwhile, try to hire an attorney, because in 30 days, whatever information you give to Mr. Guerrero, whatever arguments both of you make to me, whether to an attorney or through yourself, the court will take care of those issues that Mr. Guerrero may bring to my attention, okay?
Yes, Your Honor. Your Honor.
Yes, sir.
I have, since I have no more attorney no more, I do want to file a petition motion of temporary restraining order. I don't know, it's alleging child abuse, domestic violence. Also, hold on, I'll be sending it to his office too. Hold on, it's child abuse. Give me a second, Your Honor.
Okay, well, look, obviously, I can understand that you're making that request, but I can't take action until something is filed, either through you or your attorney, and that you serve Mr. Guerrero or his client, right? So at this point, I can understand you're making that, not making me aware of it, I can't do anything about it until you file the motion, okay?
No, I know, sir. I know, Your Honor. I've been waiting, sir, since I had my attorney on file. I wasn't able to file. That's the thing. I had called multiple to the court to knowing when had my attorney has already gotten out already. So that's why I was waiting for him to get out so I can file this petition motion. And that's what I'm saying. Like they won't let me, so I was waiting for him to withdraw from the case.
Okay.
And also, yes, and it's a lot of stuff I have here, sir. Your Honor.
Okay, well, I'll give you until the 27th, like you asked. You asked for 30 days to seek to hire an attorney, and I'll give you until the 27th of April, okay?
Yes, sir. Is that all right if I can go file the petition today? The new petition?
You can file, yeah, if you're gonna file it pro se, you can file it whenever, as long as you give Mr. Guerrero information notice, okay?
Yes, Your Honor.
All right.
Okay, sir.
Mr. Guerrero, unless he files something, we'll see you soon, or if he files something, we'll see you sooner. If not, we'll see you on the 27th of April.
Okay, thank you, Judge.
You're welcome. All right, y'all are excused.
Thank you, sir.
All right, Mr. Saldana, are you there? I know that you have a final hearing on.
Good morning, Your Honor. I'm President Redmond.
This is an adoption A004928. Is that correct?
That's correct, Your Honor.
All right, and are you prepared to go forward?
Yes, Your Honor, we are.
All right, and is this the case that Santos is also involved in?
Yes, Your Honor. He is present. I saw him. I see his screen
President
right there.
Judge.
Okay, perfect. Santos, are we ready to go forward? Yes.
Ready, Judge.
Okay, and is this a case that you all are asking that we go all into a breakout room to handle off YouTube?
Yes, please, Your Honor.
Yes.
Let me go ahead and do that. Who are the parties in this case? Mr. Saldana, Mr. Maldonado, I see Maria de Los Angeles Becerra Orozco. Anyone else that needs to be part of that?
No, Your Honor, they didn't show up. The biological mother or father have been duly noticed and they did not show up.
Judge, can I interrupt real quick?
Yes, sir.
I've got another hearing and they just called that they're ready for us. So
Okay.
Can I jump over there and jump back here?
Sure, no problem.
Perfect, Judge. Thank you.
You're here in a couple minutes.
Thanks.
Can you answer this?
So I'm going to place our court reporter. I'm going to place myself. I'm going to place Mr. Maldonado, Mr. Saldana, Ms. Maria de Los Angeles Becerra, and place Mr. Villanueva in a breakout room. Please accept the invitation. I'll join you here shortly. All right, Santos and Mr. Saldana, if y'all can accept the invitation, please.
Ms. Briones, you're here on which case? Valeria Briones.
Sí, aquí estoy.
¿En qué caso está, ma'am?
No tengo el número.
Oh, ¿es Zúñiga?
Sí,
Ok. ¿Su abogado es Greg López?
sí.
Ok. ¿Se ha comunicado con él?
No, de hecho, no sabía yo de esta reunión tampoco. No sé si él me tenía que haber avisado o no me avisó. Ahorita me habló no sé quién sería, para decirme que estaba esta audiencia. Yo no sabía nada hasta
¿Quién le
ahorita.
mandó ¿quién le mandó el link?
Una persona que me habló ahorita me dijo, me dio el link, me dio el número y que entrara, nomás. No le pregunté su nombre.
Pero no sabe si era de la oficina de Greg.
No.
Ok. Déjame. No dijo que a qué hora se iba a meter aquí en la audiencia.
Dijo 9:30.
Ok. A ver si nos podemos comunicar.
Ok.
Si puede pasar su micrófono, por favor.
All right, I'm back. Thank you for your patience. Mr. Gonzalez, I think we might still be waiting for Mr. Sabo, but I have Mr. Lopez, who I led into the room. Mr. Lopez, are you available?
Your Honor, my client and I are available, and I was just on the phone with her finalizing some details so we can read the divorce terms into the record. I'm almost done speaking to her. Can I have another 2 minutes?
Sure, no problem.
Please.
Thank you.
Thank you.
I'll definitely give you that time.
Thank you.
Hello, Judge. Mr. Stable's back, in case you can hear us.
Perfect.
Hi, Judge.
All right.
Thank you.
No problem. Let's go ahead and we can go ahead and take care of your matter. Let's go ahead and call CL 19-2484H, Mark Duarte versus Paula Rangel. Motion to exclude designated expert and motion to compel. Are these, Mr. Sables, are these your motions?
They are, Judge.
All right. I'll allow you to proceed.
All right. Judge, the topic regarding all three motions, the motions to exclude the testimony of what we'll all agree for purposes of this hearing are the plaintiff's non-retained testifying experts, a motion to exclude the testimony of, I think, who we would all agree is the plaintiff's retained testifying expert, and a motion to compel that at the time it was produced, there were no, the retained expert hadn't been designated yet, but I think the arguments apply equally to the retained testifying expert. The topic is the reasonableness of medical charges. And we're asking that the plaintiff be required to comply with Rule 194.2 F3 in regards to presenting information and documents relating to the basis of the expert's opinion. That's our request. And let me start the argument by going over with the court the plaintiff's response. And I will tell you the very first statement in the response that's supported by case law, 100% agree with. Plaintiffs say in their response, a fundamental discovery principle is that a plaintiff is under no obligation to produce its evidence prior to trial, unless such an obligation arose in response to a discovery demand or court order requiring the plaintiff to set forth the evidence supporting its claim, which is exactly what this motion is. It's exactly what they're required to do in discovery anyway, and it's exactly what this motion is. The second point made by plaintiff in his response is a quote of the rule 194.2 F3 and then an analysis of the rule. The rule states that they must produce the general substance of the expert's mental impressions and opinions and a brief summary of the basis for them, or if the expert is not retained by, employed by, or otherwise subject to the control of the parties, documents reflecting such information. That's what the rule says. However, in an obvious attempt to mislead this court when analyzing that rule, the first thing that plaintiff counsel does is remove from the rule in their analysis the part of the rule that this argument is about. They state, plaintiff states that rule 194.2 F3 merely requires that a party disclose the general substance, in quotes, bolded and italics, of the expert's mental impressions and opinions, and if the expert is not retained to produce documents reflecting such information. What their analysis completely leaves out is the portion of the rule that says that they are required not only to produce the general substance of the expert's mental impressions and opinions, but also a brief summary of the basis for them. So they analyze for 4 or 5 pages what that means with no supporting case law, with no supporting rule. They analyze the completely misstated and revised rule for the court in a blatant attempt to mislead the court. They then state to the court that these issues have been heard by many courts throughout Hidalgo County, and they've been denied summarily by every court that's heard it, implying somehow that this court is bound by what other courts in Hidalgo County have done. But the most shocking part of that statement is these virtually identical motions were heard with Mr. Gonzalez on the opposing side of these exact motions 2 weeks ago. And the motion to compel, which Mr. Gonzalez fully knows, was granted. So in addition to implying that this court is somehow bound by decisions made by other courts, he blatantly misrepresented to the court what has occurred in those other courts. He is fully aware that 2 weeks ago, in another hearing, in another county court in this county, this exact motion to compel was granted. So I'm shocked to see counsel ever make such a absolutely blatant misrepresentation to a court, but that's what Mr. Gonzalez has done in this case. The motion to compel, judge, is very simple. Rule 194.2F requires that a party state the mental impressions and opinions held by their testifying experts. If they're not retained experts, documents reflecting the information. They also need to produce the basis for the impressions of the opinion and the opinions. It's like, why? Why do you have that opinion, whatever that opinion is? In this case, why is it your opinion that the bill's reasonable? And they're required to produce documents reflecting that information. That's exactly what the rule says they have to do. I don't know what the basis of the non-retained expert's opinion is intending to be regarding that topic. I don't even know what the basis is. And they certainly have produced no documents that would reflect that basis, that would support it. So in regards to their non-retained experts, we're asking that they be compelled to produce those documents that show the basis of their opinion. Both motions to exclude are currently today set for a gatekeeper hearing, which is a hearing at which the non-moving party is required, has the burden of proof to present evidence that the expert is qualified and supporting whatever the objection is under the Dalbert-Robinson analysis, which in this case, the objection is there is no basis for the opinions stated. So there's a flaw in the reasoning because they don't present the basis of their opinion. That's the basis of both motions to exclude both the testifying and non-testifying experts. In regards to the testifying experts, they do state what the basis of the opinion is, but it kind of goes back to the qualifications. They don't really give any information as to where the basis comes from. It's effectively, there's a database prepared by somebody, no details on who prepared it, how it was prepared, where the information came from, but it's basically, there's a database. I compared the database to the information that plaintiff gave me, and that's how I came to my conclusion. Now, whoever created the database may very well have a valid basis for the opinion based on, wherever they got the information for the database from. But this particular expert just basically says, hey, there's a database. I heard it's a really good database. That's the one I used and I compared it. Therefore, I'm an expert because I compared databases. We don't even know where the information that he got that from comes from. So that's the basis, additional basis of the objection to the retained expert. That's it.
All right, thank you. Give me 1 second while I'm just taking down some notes real quick. All right, Mr. Gonzalez, your response.
Good morning, Judge. This is a personal injury case. I don't know if you follow the argument, but just so that I can put more context to it. It's a personal injury case, and like in all personal injury cases, the plaintiff, we have designated my client's treating doctors as non-retained experts to talk about the charges and the treatment. And we comply with the Rule 194, and Mr. Seba has taken the position that we have not, and is seeking for us to compel documents from those treating doctors. He wants documents showing their qualifications for why they believe their charges are reasonable. There's plenty of case law that says doctors are qualified. I cited it in my motion to opine on their own expenses. Now, Judge, may I share my screen, Judge?
Yes, you may. I think it's already open, but let me make sure. Yes, go ahead.
Okay, Judge. So I just want to, I think it's a pretty straightforward argument, Judge, and I'm not, but Mr. Sabo makes a different argument, but I just wanted to walk the court through the clear language of the rules, Judge. Rule 195.1 is the rule that governs expert discovery. It says a party may request another party to designate or disclose information concerning testifying expert witnesses only through a request for disclosure under Rule 194 or through depositions as permitted by this rule. So the only avenues are Rule 194 or through deposition. Here's the language of Rule 194, Judge. All that's required is that the plaintiff produce the general substance of the expert's mental impressions and opinions and a brief summary of the basis for them, or the expert is not retained by or employed or otherwise subject to the control of the respondent party, documents reflecting such information. So we've produced our treating doctors' affidavits. Mr. Sabo filed counter affidavits, so we can't use the affidavits to prove the reasonableness and the necessity of the treatment. But nevertheless, there are the basis for the doctor's opinions, and at the time of trial, they're going to testify as to that. So
Now,
again,
just real quick, Mr. Gonzalez, you've labeled them and identified them as non-retained experts, the treating.
Correct, Judge. And then not only do we label them not retained experts, we provided, even though they're not retained, we provided general substance of their opinions. For all of them, we put for example, Dr. Morales, this is plaintiff's first supplemental responses to requests for disclosures. For every doctor, we put Dr. Morales was testifies to the medical expenses, medical care expenses for the reasonable care of plaintiff, which are fees are usual and customary for the medical care in the state of Texas. So we've complied, even though they're non-retained experts, Judge, we've complied with the first part of Rule 194 by providing a general substance of their opinions. Moreover, since they're not retained, and there's no disagreement that they're non-retained, they're treating doctors, we've produced their medical records and bills. Mr. Sabo wants us to produce more, Judge, but that's not what the rule requires. Again, going back to Rule 195, the only avenues are Rule 194 and depositions. Rule 195, the deposition says, in addition to disclosure under Rule 194, a party may obtain discovery concerning the subject matter on which the expert is expected to testify, the expert's mental impressions and opinions, the facts known to the expert that relate or form the basis of the testifying expert mental impressions and opinions, and other discoverable matters, including documents not produced in disclosure, only by oral deposition of the expert and by a report prepared by the expert under this rule. So that applies to non-treating doctors, to retained expert, Judge. The comment to that rule says, if the expert is non-retained, says Rule 194 does not address depositions of testifying experts who are not retained, employed, or otherwise subject to the control of the responding party, nor the production of materials identified in Rule 192.3E5 relating to such experts. Parties may obtain this discovery, however, through Rule 176 and 205. Rule 176 is subpoenas. Rule 205 governs discovery from non-parties. So the rules, the language of the rules themselves tell Mr. Sabo what he needs to do if he wants documents from these non-retained experts. He needs to send them subpoenas or a deposition by written question. But he wants to put that burden on the plaintiff to produce those documents when the rule tells him exactly what he needs to do. And Mr. Sabo was aware of this, Judge, because in a similar issue, various courts in Hidalgo County have told them have quoted the Rule 194 and told them parties may obtain this discovery, however, through Rules 175, 176, and 205. So Mr. Sabo is aware of the avenues he has. If he wants that information, he's entitled to that information, but the language of the rule says you have to do it through, if they're not retained, through Rule 176 or 205, Judge. So for that reason, we asked the motion to compel should be denied, as the burden is on Mr. Sabo to request it as the rules require.
All right, Mr. Sabo.
Judge, there are no documents reflecting the basis for their opinion. None.
So, but they're going to be coming to testify, correct, in court?
Correct.
And
Right.
When you file your counter affidavit, that forces them to bring them to trial, correct?
Correct, Judge, but there's still
it forces them to prove the issue through expert testimony, whoever that happens to be. And before I have to either cross-examine them in a deposition or at trial, the rule requires that certain documents be produced. I need to know what the basis of their opinion is before I take a deposition, before I cross-examine them at trial. They can't just come in and say, this is a treating doctor. I don't need to tell you any additional details about their opinion. That's not how it works. I'm entitled to know why. Why do you think that those are reasonable? And documents reflecting such information. That's what the rule says. I'm entitled to know that before we get to the next step. The details, I get it. I need to take a deposition or cross-examine them, but I need documents reflecting the information in order to have something to cross-examine them on. I don't know. I mean, at this point, it's a.
But are you required?
Because I say so.
But are you required to have that information before you take a depo?
The rule 194.2 F3 says that they have to produce that information in response to disclosures. So that's way before depots, certainly way before trial. So that's the part that's lacking. There is no documents reflecting basis for the mental impressions and opinions. There are none produced. I'm entitled to that before the depo, before the trial testimony, so that I know what I'm talking to them about.
I mean, and again, you all are educating me, and I thank you for that. But are you required to provide that to Mr. Sabo before the deposition so that he can have that for proper cross-examination and preparation for the deposition? Because I don't think he's taken that deposition. Is that correct, Mr. Sabo? You've yet to take that deposition?
That's correct.
Okay.
Correct, Judge. And just going back to the clear language of the rule, Judge, all that's required is a general substance. That's even for retained experts, which the burden is higher for the plaintiff or the party retaining them. The general substance of the expert's mental impressions. Rule 195 says.
Hold on, let's read the whole part. You skip it again, just
Judge,
like you did when you recited it here. He's skipping the whole rest of the rule, Judge.
All right, well, let's go back. Let's figure it out. Okay. The general substance of the expert's mental impression and opinions and a brief summary of the basis for them, which I think they've already done that, right? They gave you that.
Not the basis for them part, Judge.
Correct, but
that's the part that's lacking, is the basis for them part.
Okay, so what you want them, Mr. Sabo, is you want him to say, my fee is my fee because I was trained at Johns Hopkins. I am certified to X, Y, and Z. I have X number of years of experience, and my fee in the industry in this area is Y. Right? That's what you're asking for?
Well, I think it goes beyond that. Why is it reasonable?
Because he says it is.
Well,
why do you charge what you charge? Is there a book that says lawyers have to charge at X amount? No, it's a function of time. It's a function of
in order for a lawyer to testify that their fee is reasonable, there are 7 factors that are taken into consideration in order to make that determination. I know you're familiar with those cases. In this case, Mr. Gonzalez wants to take no factors into consideration and just allow the expert to say, I say it is, therefore it is. No expert testimony works that way. There's got to be some underlying basis for it. For example, that's what everybody that does this that's similar to me charges. That's what everybody that does this gets paid. That's what I always get paid. Another example.
That would be sufficient?
If there were documents produced reflecting that opinion, yes, that would be sufficient.
So an affidavit.
To meet the disclosure.
So an affidavit. An affidavit from him saying, I charge what I charge because that's what everybody charges and I've become accustomed to charging that amount.
Well, in addition to that, there's got to be documents reflecting that. In other words, he can't just say that without any support. Kind of like the retained expert.
Yeah, but I mean, okay, and maybe we've had this conversation before. I know we have, to some extent we have, but I mean, how is that any different than where you come from and the defense, where you all have a program that says that the reasonable fee should be Y, right? I mean, that's the argument here, right? You're arguing that the fees are not reasonable because you have a system or a program or some expert that says it's all BS and it should be 50 cents on the dollar, based on what the treating doctor is charging.
Well,
right?
we actually present that in the form of actual like substantive information.
Evidence.
Why?
Or what? Like
Sure.
how?
Yeah. A good example, and obviously this is not entirely the basis, but if you look at the counter affidavits that were submitted in this case.
You can share the screen. That'll help me tremendously if you could do that.
I don't have the document on the device that I use for Zooming.
Mr. Gonzalez, do you happen to have that counter affidavit?
No, Judge.
See, in the counter affidavits, the folks that do the counter affidavits, they outline not only what the reasonable fee is, but why. And the why, they obviously plaintiff's counsel doesn't like the why, but the why is because, for example, Medicare charges X, and to calculate the reasonable profit for a facility that provides medical services, some factor of that is a reasonable fee. All of that in detail with numbers is outlined in the counter affidavit.
But okay,
the source of the information.
Right. So, but if I follow that argument, Mr. Sabo, and I've used this before, because a court-appointed lawyer takes on a case at a reduced fee, that now becomes a reasonable fee. So whatever the county is willing to pay a defense lawyer per hour, which is $70 an hour, right, for out-of-court time, that has now become the industry standard for Hidalgo County as to what all lawyers in private practice should charge, based on your argument.
There's a lot more to it than that.
I think that's not. I do apologize. I don't think that's those are the issues in these motions, Judge.
There's a lot more
issues, or they are the issues.
They are not, at least not for the motion to compel. I don't think that that's the issue. The issue is Mr. Sabo is creating a burden on the plaintiff, a new burden on the plaintiff that is not in the rules. All the plaintiffs have to do are designate her treating doctors, which we did.
And I think that Mr. Sabo is going a step further and saying that those treating physicians should tell me why they're charging me.
Correct.
And I should have that information before I go to a depot, so that I can rip that new doctor new what.
There you
Judge,
go.
That's the reality of it.
that's not the issue either, Judge. The issue is how should that
Exactly.
information, I don't know, well, I'm not arguing with Mr. Sable that if he wants that information, he should have it. The issue is he wants to put that burden on the plaintiff to produce documents from non-retained parties outside of their control. The rule says experts outside of your control. So Mr. Sable will say, plaintiff, they're outside of your control, but you produce X, Y, and Z. That's the issue, Judge. The issue says that the rule says if he wants that information, he has to subpoena it through Rule 176 or obtain it through Rule 205. So Mr. Sales makes the issue is he's entitled to information. How should he get it? The rule says through Rule 176 and 205. The plaintiff, we're going to bring
194.
We're going to bring
Step one is 194.
Judge, we're going to bring the treating doctors to trial. At that point, if Mr. Sable chooses not to exercise his rights under Rule 176 and 205, then pre-trial he can do a voir dire outside the presence of the jury and question them. But
that's what we're here for.
Nothing in the rule. See, that's the issue, that nothing in the rule requires that he's creating this burden where now every single plaintiff has to go get an affidavit or documents that he can't even tell us what exactly he wants from every treating doctor. That burden has never been the burden of the plaintiff. We have to bring him to trial, and at that point, we can examine the doctor. But he wants to do it pre-trial, and the rule says no.
Expert discovery.
The rule says that he can do it, but he has to go and file his subpoena. The problem is that he's probably not going to get anywhere because the subpoena can't be specific enough to get what he wants.
Correct, Judge. And he wants us to get it. They're experts outside of our control. So how do we have standing? How can our plaintiff be penalized?
Then they should be allowed to testify, Judge, if they
Judge,
can't do it.
The rule.
Does the rule say that? I mean, I know that in theory that's your argument, right, Mr. Sable? But does the rule say that they shouldn't be allowed to testify if they can't produce the information that you yourself can go and get by way of depo or subpoena, which you've yet to do?
That the rule requires what it requires. 190, step one, before we get to
he wants the plaintiff to do his job. That's not the burden, Judge.
It's not my job it's not my job to produce the documents required to be produced in 194.2. 194.2 F3 puts the burden on the party who has identified the testifying expert to produce certain information. Number one, expert's name, address, and telephone number. Number two, the subject matter on which the expert will testify. And then number three, makes a distinction between retained experts and non-retained experts. Retained experts have to produce a general substance of the expert's mental impressions and opinions and a brief summary of the basis for them. Non-retained experts, they have to produce documents reflecting that information. That's the disconnect. They have not produced documents reflecting the basis for the expert's opinion.
Like I said, Judge,
What
Mr. Sable
is it?
is creating a new requirement in the Texas Rules of Civil Procedure
I'm reading the rule.
in which every plaintiff across the state of Texas not only has to produce the emergency room bill and the emergency room hospital records, he also has to go to that hospital and have them create a report.
It's completely false. That's completely false. Someone qualified to testify that
Well, either way, Judge.
that the bill is reasonable needs to be designated. If they want somebody to testify that a bill is reasonable, someone who's qualified to say that has to be designated, and the information and documents outlined in 194.2 have to be produced. It doesn't have to be the person from the facility. In fact, the Supreme Court thinks that probably those people don't know and aren't qualified to give those opinions because of the way medical billing has become so complex. In this case, plaintiffs have hired a expert outside of the treating physicians who, like I said, all he basically did was said, hey, there's a database. It's a good database. And I compared that database. There's no information regarding the source of the database, the information.
Have you taken his depo?
About the database? No, I would like the documents before I take his depo.
Judge,
But we can do that. I mean,
Judge,
it will make for a much longer deposition if we have to go over all of the production of documents and what he relied on rather than him produce it ahead of time. But we can do it that way.
Judge, also, Mr. Sable's motion to compel argument, you're familiar, Judge, with Chapter 18 that allows a plaintiff to use affidavits. It would completely, to prove a reasonableness and necessity at the time of trial, Mr. Sable's argument completely would render 18 meaningless. Say plaintiff produces his affidavits. Mr. Sable then files his motion to compel, saying, no, doctor, you can't testify. I need documents showing why you believe that charge is reasonable. This motion had nothing to do with counter affidavits. He doesn't need to file a counter affidavit. He can just wait. Plaintiff files the motion, his affidavit. Then Mr. Sable files a motion to compel, taking the position, affidavit is not sufficient. Tell me why you believe that's reasonable. It would read out Chapter 18, Judge. This argument that Mr. Sable, or this tactic, or the way he's trying to create a new duty on the plaintiff, it fails for many reasons, and it creates a heavy burden on the plaintiff that's not required by the rules, Judge.
Everything Mr. Gonzalez just said could not be more wrong. This motion has absolutely nothing to do with Chapter 18. In fact, I will agree with Mr. Gonzalez that there are a few bills that were supported by Chapter 18 affidavits in this case, for which counter affidavits were not filed. Those are not, there's not an argument being made regarding those bills at all.
Why not, Judge?
Those are sufficient to support a finding just by the affidavit alone that does not have a counter affidavit. That's how Chapter 18 works. Once the counter affidavit was filed, which they were in, I think, 3 of the bills, that's when the issue regarding being required to present expert testimony comes into play. So it's only those bills that are the subject of this motion to strike or exclude, but he doesn't specify in his designation which bills each designated expert he's intending to have them testify about. Like, he doesn't say, this is the doctor from the hospital, he's going to talk about the hospital bill. He doesn't say that. He just blanket says, these are the people and they're going to talk about bills. So I don't know from his designation who's going to talk about what. That's why it's done this way.
All right, Mr. Gonzalez, but you don't have a problem becoming more specific or getting more specific as to who's going to testify as to what.
There is no hospital in this case, Judge. We have been specific, Judge, on every single one. For Stone Ridge, for example, Judge, Dr. Benjamin rendered medical treatment to plaintiff for the injuries and damages sustained as a result of the accident. He will testify as to the treatment. Will testify as to the medical care of.
It says there, Dr. Morales will testify. Is it
Dr. Morales? Yeah, which is the doctor on top. So Dr. Morales will testify.
Okay, is that just an error where it should say Dr. Barnett will testify as to the care on that second go down?
Correct. No, I think Dr. Morales is the one that will come in and testify as to the bills. But since Dr. Benjamin appears in the medical record, we designated him in case we need him to also speak as to the treatment he rendered.
Okay.
So the proper way for them to do this, Judge, would be to say, Dr. Let me just say Morales, since he's the one pulled up. Dr. Morales is going to testify about, and then the relevant part would be the reasonableness of the bill from Stone Ridge.
Well,
And then-
it says there, does that not give you enough? Will testify as to the care, treatment, physical limitations, reasonable and necessary medical charges. He'll testify to reasonable and necessary medical charges.
From where?
Diagnosis, prognosis, prescribed medications, future care expenses of plaintiff, which arose as a result of this incident.
Well, which ones? There's like 7 or whatever facilities. Which
they're all,
ones is he going to talk about?
They're all under, so for Dr. Morales, he is custodian of records, he's for Stone Ridge. For Dr. Kevin Legendre, he's from Open MRI. So every doctor has a listed facility, Judge.
It doesn't say that in their designation, Judge, which one. That
Well,
they're
the paragraph is underneath, his personal information is part of the designation, Judge.
It doesn't say, there is nothing in this designation that if Dr. Legendre started testifying about the bill from Stone Ridge, for example, I could not, if I objected and said, well, he didn't say he was going to talk about that in the designation. Well, he did. It says, it's very vague. As to what he's gonna talk about.
If that's
Just
the only
basically
issue,
says bills. That's step 1. There's 4 steps of
if that was the only issue Mr. Sable had, even though there's a name of the facility underneath, we can include a sentence.
That's absolutely not the only issue that Mr. Sabo has. There's plenty. That's the first.
That's the point, that instead of facility, we could put Open MRI instead of from the facility to which he treated the plaintiff. We could put the name, but I don't think that's Mr. Sable's issue. He wants more, and unfortunately, Judge, all the rule requires is the general substance. If he wants more, it says if a party may obtain discovery concerning the subject matter on which the expert is expected to testify, the mental impressions, opinions, the facts known that relate or form the basis of the testifying mental impressions and opinions. So if he wants more than the general substance, including documents, he can only do it by oral deposition or by a report. That's for the retained experts. For non-retained, the comment to this rule, Judge, says if you're not retained, then the party may obtain discovery through 176 of 205. So
he's leaving out the rest of the rule, Judge, again.
Well, okay, what is the rest of the rule, Mr. Sable?
Okay, Judge.
What is the rest of the rule?
194.
The rest of the rule, as you see,
Judge,
in his discussion, he says merely requires that a party disclose the general substance of the expert's mental impressions and opinions, and if the expert is not retained to produce documents reflecting such information. That's where he's trying to mislead the court by leaving out this part. It says, and a brief summary of the basis for them. That's the part that he wants to pretend doesn't exist.
Okay,
a brief summary of the basis for them, documents reflecting such information. It's documents reflecting both parts, general substance of the expert's mental impressions and opinions, and a brief summary of the basis for them. The brief summary, the basis for them part of that rule that they're required to produce, that's the part Mr. Gonzalez wants to pretend doesn't exist. It's there. They've got to do what the rule says.
We can read
not part of it.
Judge, I can read the entire rule, but it says the general substance of the expert's mental impressions and opinions and a brief summary of the basis for them. I don't think Mr. Sable disagrees that this first portion applies to retained experts. And my client's treating doctors are non-retained outside of his control.
Documents reflecting the information, documents reflecting such information is what is required to be produced. They want to pretend that it's only the first half of.
No, that's not the point, Mr. Sable. He's saying that it's only for retained experts, and the physicians are non-retained.
Right.
Judge,
the non-retained are for the non-retained experts. They're required to produce documents reflecting such information.
Mr. Sable, I think we agree with that part of the rule, and Judge, I agree with Mr. Sable on that part of the rule. The rule says the general substance of the expert's mental impressions and opinion, or a brief summary of the basis for them.
And
This applies.
and summary of the
Hold on,
basis.
Mr. Sabo. Judge, I think we both agree that this first portion applies to retained experts that are within the control of the plaintiff. The treating doctors fall under the latter part, Judge, because they're outside of our control. So if you're outside of the control, all you need to produce is documents reflecting the general substance of their mental impressions.
Right.
So
no, and the basis for them.
Right. All right, Judge.
That's
So
still part of what they're required to produce.
Okay, but Mr. Sabo, if what is this? Would you agree that 194.2F3, that is a totality of that rule, that nothing was left out?
The part that has the highlights, yes. The part where they're trying to summarize it.
No. Is that the rule? I'm just, because I don't have my code. So 194.2F3, is that the rule? Is there anything that he left out?
Not there, no.
Okay.
Not there. That's complete.
Because it
The
says,
highlighted part.
okay, because if I go and say, and I'm following Mr. Gonzalez, he's saying if it's a retained expert, then the general substance of the expert's mental impression and opinions and a brief summary for the basis thereof. Okay, so that means a retained expert, you must provide a brief summary of your impression and opinion. But if it's a non-retained expert, if they're not under your control, and that's where it says comma, or if the expert is not retained by, employed by, or otherwise subject to the control of the responding parties, it's documents reflecting such information. It doesn't say, and a brief summary for the basis of them or for them.
No, the such information that they're required to produce documents reflecting includes everything before or.
Judge, it's the plaintiff's position that we produce.
General substance of the expert's mental impressions and opinions and a brief summary of the basis for them.
Correct, Judge.
That's what the documents reflecting such information refers back to. The entirety of everything in that rule.
So your argument is that that rule applies for both testifying, retained and non-retained experts alike, both.
Well, it's different. For if it's non-retained, it's documents reflecting such information.
Correct.
But all inclusive of what documents reflecting such information means is everything from the beginning up until the comma or.
What would you view as documents reflecting such information? What is that to you? What does that mean to you?
Documents reflecting the basis of their opinion. I don't.
So then there is no difference between a retained expert and a non-retained expert, according to you. You want them, whether they're retained or non-retained, to give you their mental impression, their opinion, and a brief summary for the basis of it.
Well, they don't have to write a report explaining what the documents mean, like a retained expert would have to.
So
but they do need to produce them.
Judge,
that's the difference. I don't need to do a report.
A retained expert doesn't need to write a report, Judge. He can just be presented for deposition.
Correct.
So Mr. Sabo, according to Mr. Sabo, the burden for non-retained experts is even higher because we have to show documents reflecting their mental impression and opinions. And Judge, to give light, so our position, Judge, is that we produced those documents and we said the basis for their opinions are going to be their medical bills and records, which we have produced. Mr. Sabo wants to read that this means more. And in order for us to give light to 194, we have to read it in connection with Rule 195, Judge. Because again, the only two ways that a party can obtain discovery is only through 194 or through depositions. Depositions is Rule 195.4. So we have to read both rules together to understand what Rule 194 means, general substance documents. We have to read Rule 195 in conjunction. And it says, in addition to Rule 194, a party may obtain discovery concerning the subject matter. So again, 194 all requires a general substance. If the other party wants more, then including documents, it can only be obtained by oral deposition, Judge.
I don't even know what the basis of their opinion is.
Correct, Judge. Sorry, Judge. General substance, general. If he wants more, including documents by oral deposition of the expert. And that's for retained experts, Judge. If we go to the comment, it says if it's not retained, parties may obtain more than the general substance through rules 176 and 205. Again, if we go back to the same argument, Judge, we don't disagree with Mr. Sable. If he wants that information, he's entitled to it. He chose to not exercise his rights under the rules. The plaintiff can bring these treating doctors to trial, and at that point, he's free to voir dire them. But he chose not to exercise his rules, and then he wants to put the burden on the other party.
Before we get to that point, Judge, I'm entitled to the information that they're required to produce in disclosures, and that includes information relating to the basis, documents reflecting the basis of their opinion. I don't even know why they think their bills are reasonable.
But Mr. Sable,
I don't know that.
You haven't even taken their depo to know, or even to know whether they'll give you that information. You're assuming that they're gonna dig their heels and not give it to you.
In order to be allowed to testify on the topic, and that takes us to the motion to strike. In order to be allowed to testify on the topic, they've got to have one. They can't just come in and say, "I say so, therefore it is."
Correct.
Expert point doesn't work that way. They need to have a basis for their opinion. They need to be qualified, which I don't think they are. And we're supposed to have a hearing today to determine that. And they don't have a basis, a valid basis with a foundation to it, to their opinion. They got to have both, and they don't. And prior to taking their depo, I'm entitled to basic information as to what that basis is. And that I don't know what it is. Document reflecting the basis.
The rule speaks for itself, Judge. Mr. Sable can comply with 176 and 205. The rules give him that tool, Judge. If the doctors don't comply, then at that point, he can come to the court and say, "Hey, Judge."
I would agree with that. I would agree with that.
And
I would agree that he has those remedies, and if they don't comply, you can then come to the court and ask for relief. But it's premature at this point. You haven't even taken their depo, Mr. Sable.
But my first remedy is to compel the plaintiffs to comply with 194.2 F3.
Why? Because that makes your job at a depo easier?
It's because it's what the rule requires, Judge. That's why.
Yeah, but you can ask them, and if they don't tell you, then you can come back. I think you're putting.
I did. They didn't tell me. I'm coming to the court asking for the plaintiffs to give me that.
Judge, the rules that's outside of the party's control. He wants us to compel the plaintiff to produce documents from a party outside of our control. That's why the rules understand that. It's a basic principle. You can't compel the party to produce documents outside of their control, from a party outside of their control.
They got the bill from the guy. They can get
a remedy. If Mr. Sable enforced his rights under the rule, the doctors didn't comply, then at that point, the plaintiff would be in a position to having to justify why his doctor should testify when they haven't complied with 176 and 205. But that hasn't happened, Judge. It's premature. We should be entitled to bring our doctors to trial, and at that point, if he wants to voir dire them or get their information before trial, he can do that, Judge. But he chose not to exercise his options. We'll subpoena them to trial, and at that point, we can go through the qualification analysis.
That's the motion that's set today. The gatekeeper hearing. That's what's set today. For typically, when there's a gatekeeper hearing, the party with the burden, which in this case would be the plaintiff, has the expert testify to support whatever the objection is. In this case, it's in regards to qualifications and the basis of their opinion, the foundational basis of their opinion. They're not here. So there is no evidence to support that these experts are qualified, and there is no evidence to support that they have a basis for their opinion that passes the Robinson-Daubert challenge standard.
Judge, I put Mr. Sable's tactic in writing in my motion. It's an unattainable perception, Judge, would affect discovery in all civil cases across the state. This is how it would go. Both parties would designate experts as required by Rule 194, provide their journal substance. Neither party would attempt to depose nor seek discovery from each other's expert as required by the rules. Both parties would then move to exclude each other's experts by filing the same motion Mr. Sable filed. They're not qualified. They haven't produced any documents. So the burden is on the requested party. If you want to obtain more than the general substance of the expert's opinion, then you do it via depo. Mr. Sable's tactic is unattainable. He wants to wait until the eve of trial. The boilerplate motion, Judge, has nothing specific to any expert. He copies and pastes the name of the treating doctors in every case and files the same motion. We could file this motion in every single case across the state of Texas. No, don't do any expert discovery, and then we both cross motions to exclude. You haven't given me anything. So it's just unattainable tactic, Judge.
Judge,
He has not requested nor sought
they have
the position
to,
of our expert.
at the very minimum, they have to comply with Rule 194.2 and produce that information and documentation that's required.
Judge,
That's the part that they haven't done.
For the retained expert, we don't disagree. For the retained
Propose.
expert, and we have complied. We provided Mr. Sable with this report, and he still says that this is not enough, even though he hasn't taken the deposition of the expert. He put, I have more than 40 years of healthcare experience. He has founded and managed multiple spinal diagnostic and pain practices, an ambulatory surgical center, a pharmacy, a diagnostic laboratory. In each instance, he said or collaborated in setting the charge master and fee schedules for the facility or provider group. Our retained expert provided that report, and Mr. Sable filed the same motion he filed as for the treating doctors, saying that's not enough, give me more. The burden's on him to depose the doctor, Judge. He has not. So
Judge, in regards to the testifying expert, I agree that the motion to exclude the testimony was filed because there was a deadline to file the motion. But I agree that it ought to more appropriately be heard after the deposition, because he has at least complied with basic information. The others have not.
Judge, the principle is the same for both. We properly complied with the Rule 194 as to the treating doctors and retained experts. Mr. Sable chose not to seek a deposition of the expert or subpoena the non-retained experts, and then he waits to the eve of trial to file these motions. So it puts the plaintiff in an unattainable position in which now we have to produce documents that we're not required to by the rules. So,
well, the concern that it also has is that it basically almost puts in a built-in continuance, and you guys are at number one.
Correct, Judge. So I think the motions to exclude should be denied. Motion to compel should be denied. Discovery period has closed, and we will announce ready for trial.
Well, you're at number one, Mr. Sable, and at this point, the court is of the opinion that the motion to exclude is denied and the motion to compel is also denied. We'll see you on April the 7th at 1:30. Although at that point, it's just motion and limiting issues, because you guys are number one for the week.
Correct, Judge. We know it's ready. Thank you.
Judge, I would like to be given the opportunity to take the deposition of the retained expert.
You got until the 7th to do that, and make every effort, Mr. Gonzalez, to make him available.
Yes, Judge.
I hear that he's not being made available. Then I might entertain a continuance.
No,
but
Judge,
I don't want this to be a built-in continuance. And I think
the expert testified as to $6,000 in medical expenses, Judge. If he's not available by April 7th, we'll agree to de-designate him, Judge. That should not be an impediment to trial.
Done.
Okay, then I'll just on the record ask for dates over the course of the next 2 weeks for his deposition.
Correct, Judge. And if we cannot make him available during those 2 weeks, we hereby on the record agree to de-designate him and not call him to trial.
Perfect. All right, we'll see you guys for trial on the 11th. You guys are number one.
Thank you, Judge.
All right, thank you, Judge.
Mr. Lopez.
Your Honor, good morning. We're ready to proceed with proving up a divorce.
All right, F 5242-21-8 in the matter of the marriage of Valeria, I hope I pronounced that right, Valeria Zuniga and Ernesto Briones.
Your Honor, Greg Lopez, I represent Ms. Valeria Zuniga. She is present via Zoom. We're going to prove up this divorce. She will require an interpreter.
All right. Mrs. Zuniga, can I have you please unmute yourself and raise your right hand?
Levante su mano derecha, por favor.
¿Perdón?
Levante su mano derecha.
Do you sort of tell the truth, the whole truth, and nothing but the truth, so help you God?
Juro que el testimonio que va a dar esta mañana será la verdad y solamente la verdad.
Lo juro.
I swear.
You may proceed, Mr. Lopez.
Puede bajar su mano.
Please state your full name.
Diga su nombre completo.
Valeria Guadalupe Zúñiga Hernández.
Valeria Guadalupe Zúñiga Hernández.
And ma'am, were you living in the state of Texas for a 6-month period prior to filing this divorce?
¿Estaba viviendo en el estado de Texas 6 meses antes de que archivar este divorcio?
Sí.
Yes.
Were you a resident of Hidalgo County 90 days prior to filing this divorce?
Era residente de este condado de Hidalgo 90 días antes de que archivara este divorcio.
Sí.
Yes.
And ma'am, you are seeking a divorce from Mr. Ernesto Briones.
Y usted está pidiendo el divorcio de Ernesto Briones.
Sí.
Yes.
You know that he signed a waiver of service on this case. However, do you know whether he's attending today's hearing?
Sabe que él firmó una renunciación de servicio, pero ¿sabe usted si él está atendiendo hoy la audiencia?
No, no,
No.
no.
Okay. All right. Now, on your petition, ma'am, you indicate that you and Mr. Ernesto have 3 children.
En su petición usted indicó que usted y el señor Ernesto tienen 3 niños.
Sí.
Yes.
Did you adopt any other children or are you currently pregnant?
¿Adoptaron otros niños o usted al momento está embarazada?
No.
No.
And as for the children, ma'am, you're asking that you and Ernesto have joint custody of the children, but that you designate the primary residence.
Y tocante a los niños, usted está pidiendo que tengan custodia junta usted y Ernesto, pero que usted tenga la designación de la residencia de los niños.
Sí.
Yes.
And Ernesto is to pay you child support.
Y Ernesto es de pagarle a usted manutención para los niños.
Sí.
Yes.
And the child support, ma'am, is going to be set at $1,300 per month beginning April 1st, 2022.
Y la cantidad de manutención que se está pidiendo que se ordene son 1,300 mensualmente, empezando el 1 de abril 2022.
Sí.
Yes.
And there will be 2 reductions or step downs as follows: $1,083 and $866.
Y va a haber 2 rebajas de que sería a $1,083 y $866.
Sí.
Yes.
That is the reduction, Valeria, for, you know, when he has to pay child support for 2 kids and then has to pay child support for 1 child. I explained that to you.
Esa es la rebaja cuando él va a tener que pagar manutención por 2 niños y luego para cuando pague nomás para 1. Le expliqué eso.
Yes.
Okay.
Yes.
Digo, sí.
All right. And Ernesto will have standard visitation with the children as per the family code, beginning at 6 p.m. on the first, third, and fifth Fridays and ending at 6 p.m. on Sundays.
Y el resto va a tener visitación estándar como pide el código familiar, empezando a las 6 de la tarde y terminando a las 6 de la tarde también, que va a ser primero, tercero y quinto fin de semana.
Sí.
Yes.
And you ask that the exchange of the children be at the DPS office that's on North Expressway 281 in Edinburgh.
Y el intercambio de los niños, ¿está pidiendo usted que sea en la oficina del DPS, que está por la 281?
Sí.
Yes.
And now you have a young girl named Sofia Briones, and she is barely a year and like a month old.
Y tiene usted una niña que se llama Sofía Briones, que apenas tiene como 1 año y 1 mes.
Yes.
I can hear, no lo oí.
Perdón, ¿la pregunta cuál fue?
¿Usted tiene una niña, Sofía Briones, que apenas tiene como 1 año y 1 mes?
Sí.
Yes.
And what you're asking is that the standard order does not apply to this little girl, the standard visitation order, until she turns 3 years old.
Y lo que se está pidiendo es que esta orden estándar que no aplique con esta niña hasta que obtenga la edad de 3 años.
Sí.
Yes.
And from here until she turns 3 years old, all visitation with this little girl will be as per agreement of the parties.
Y lo que se está pidiendo que hasta que esta niña obtenga la edad de 3 años es que las visitaciones con ella sea al acuerdo entre ustedes.
Sí.
Yes.
All right. And ma'am, you told me that the children have Medicaid or CHIPS, correct?
Y usted me avisó que los niños tienen Medicaid o CHIPS.
Medicaid.
Medicaid.
And so Ernesto will have to pay $100 per month in medical support beginning April 1st 2022.
Entonces Ernesto va a tener que pagar $100 mensuales por aseguranza médica, empezando el 1 de abril 2022.
Sí.
Yes.
All right. And ma'am, other issues is you will keep the property located at 6329 Delta Street in Edinburgh?
Y otra cosa, usted se va a quedar con la propiedad que está en la 6329 Delta calle en Edinburgh.
Sí.
Yes.
And you will keep the debt on that property?
¿Y usted se va a quedar con la deuda de esa propiedad?
Sí.
Yes.
And your husband is to sign a deed within 30 days of the entry of the decree?
Y su esposo debe firmar el decreto para entre 30 días de que se firme el decreto final.
Sí.
Yes.
And ma'am, he left some pending bills on that property, and you're asking that your husband pay you $1,300 on the date the divorce decree is signed.
Y Ernesto dejó una deuda en esa propiedad. Usted está pidiendo que le pague a usted $1,300 en la fecha que se firme el decreto final. ¿Perdón?
Yes.
Yes.
Okay. And he is also to pay all property taxes up to tax year 2021 on that property.
Él es de pagar todos los impuestos que se deben a esa propiedad hasta el 2021.
Sí.
Yes. And let's see, the total amount he's supposed to pay you because of the debt he left on the property for utilities, etc., is $2,300.
La cantidad que él debe pagar a usted que se deba de deuda de esas propiedades es $2,300.
Yes. Sí.
Yes.
In addition to the property taxes that he has to pay.
En adición de los impuestos de las taxas que él debe. Una respuesta.
Sí.
Yes.
And he is going to keep a 2009 Chevrolet Malibu.
Y él se va a quedar con un 2009 Chevrolet Malibu.
Uh-huh. Sí.
Yes.
And he is also going to keep all tax refunds from 2021, tax year 2021.
Y él también se va a quedar con todos los reembolsos de impuestos del 2021.
Sí.
Yes.
And finally, ma'am, you're asking that this court award you $1,500 in attorney's fees because you're the one that paid for this divorce.
En adición, usted le está pidiendo a la corte que le dé $1,500 honorarios de abogado, como usted fue la que pagó por este divorcio.
Sí.
Yes.
And that he is to pay you this amount within 60 days of the date of divorce.
Y que él le pague a usted esta cantidad entre 60 días que se finalice este divorcio.
Sí.
Yes.
And are you asking to change your name to your maiden name?
¿Está pidiendo de cambiar su apellido a su apellido de soltera?
Yo todavía tengo el apellido de soltera, no tengo el apellido de él.
I still have my maiden name. I don't have his last name.
Okay, so you want to keep your maiden name, correct?
So, entonces quiere quedar con su apellido de soltera, ¿correcto?
Sí.
Yes.
Please tell me what name I should put on the decree.
Por favor, dígame qué apellido para poner en el decreto.
Valeria Zúñiga.
Valeria Zúñiga.
Ma'am, are you asking that the court grant this divorce?
¿Le está pidiendo al corte este divorcio?
Sí.
Yes.
And the reason for the divorce is simply conflict of personalities between you and your husband.
Y la razón por el divorcio es simplemente conflictos de personalidades entre usted y su esposo.
Sí.
Yes.
Is there anything else, ma'am, that we need to add onto this divorce decree or any question that you have for me?
¿Hay algo más que tenemos que agregar a este decreto final del divorcio o alguna pregunta que tenga?
No, nada más quería decir que la mitad él por eso se va a quedar con todos los ingresos del income tax que hizo, porque yo le di a él la mitad quedamos que él me iba a dar la mitad del income tax, entonces yo le dije que él se quedara con la mitad para yo poder quedarme con el solar.
Well, just on the tax returns, that's why he's keeping everything, because I had given him half because I was going to keep the property.
Right, ma'am. We've asked that the property be awarded to you along with the debt, remaining debt on the property.
Sí, ahora estamos pedido que la propiedad se le dé a usted
Ok,
junto con la deuda que se deba.
ok.
Okay.
Is that all, ma'am?
¿Es todo?
Sí, es todo.
Yes, that's it.
That's all I have, Your Honor.
All right, thank you. The court's going to go ahead and take judicial notice of all documents in the court's file. This action was filed on December the 6th, 2021. The court's going to find that it's been on file for the requisite period of time. There was also a waiver of service that was executed and filed with the clerk on February the 22nd of 2022. That being the case, the court is going to go ahead and grant the divorce along with all relief that's been read into the record. Your divorce is hereby granted, Ms. Zuniga. Good luck to you.
La Corte Laboral divorcio como lo ha pedido, Ms. Zúñiga. Buena suerte.
Gracias.
Thank you.
All right, Mr. Lopez, we'll wait for an order to be submitted.
We'll submit it very soon, Your Honor, with
All
my
right.
client's signature. Thank you.
Eddie. All right, thank you so much.
Ya se puede retirar.
Bueno.